So in the previous lesson, what we did was talk about the breach of a duty of care. We introduced the subject of breach, and we noted that this was the next major hurdle for any claimant who wishes to bring a successful claim of negligence against a defendant. We also then finished by thinking about this idea that the breach of duty of care is one that is measured on the basis of something known as the standard of care. Now, in this lesson, we are going to talk about the standard of care in more detail, and we're going to essentially define what the standard of care is, and then look at some of the basic case law which establishes how the standard of care is applied. So, the standard of care, as we noted in the previous lesson, is the benchmark for what is expected of an individual who has a duty of care to act in a particular instance and to adhere to. So, in circumstances where there is an individual or as an organisation, some kind of defendant who is shown to have had a duty of care to a claimant, they have to act with that duty of care to a standard, the benchmark, which is essentially required as a bare minimum for an individual to avoid liability. They don't necessarily have to go above and beyond the standard of care to avoid liability, they just have to meet the standard of care. And a breach of the duty of care is represented as a falling below what this standard actually represents. If they fall below the standard, as I've just said, then they have breached their duty and could be liable in negligence. You then have to go on to the next step, which is, of course, trying to show that this breach, that this fall below the duty of care was the cause of the damage that is being claimed for by a claimant. So essentially then, what is the standard of care? Is it one that we can apply universally, or is it something that we have to apply on a factual basis on each individual case? And how is it measured? How do we measure what the standard of care actually is in a particular circumstance? Well, the courts were very, very keen to, at a very early stage in the development of this area of the law, suggest that the standard of care ought to be an objective test. It ought to be one that does not shift and change depending on the facts of a circumstance, or even the particular issue at hand, or even the person who is being accused of some kind of negligent action. So, since it's not up to the court to decide a specific standard for every possible circumstance, this would be unrealistic in the circumstances, the general approach is that the standard of care is the act of a reasonable person. So essentially, what would a reasonable person do in the circumstances if they had a duty of care to the claimant and the exact same things were to take place? If a reasonable person would have done what the defendant did, well then that shows that the defendant has met the standard of care. If a reasonable person would have acted more and would have acted in a different way so as to try and avoid the damage being caused, even if they were successful or not, then this would suggest that the defendant has fallen below this objective standard and therefore may be liable for breach. The case of Blythe and Birmingham Waterworks from 1856 illustrates that a, quote, reasonable man and woman, but okay, this is 1856, don't forget, is the defined benchmark for which an individual is to be judged on the basis of the standard of care. It makes it an objective standard. What would a reasonable man or woman do in the circumstances, and if they would have done something differently, or maybe would have done more in the circumstances of this, maybe more of the same thing, then the defendant is likely to have fallen below this standard and is likely to have breached the standard of care. It is specified that the reasonable person doesn't describe an actual man or a woman. It is not what this specific person would do. They essentially, when we talk about a reasonable man test or a reasonable person test, we essentially are suggesting that there is a hypothetical individual who has the most basic standard of temperament. They are neither too cautious, nor are they too risk-taking. And the point of this, the point in that particular passage, is to suggest that because they are neither too cautious or too risk-taking, you're not subjecting an individual to too harsh a standard. If the reasonable person was too cautious, then the standard of care would be too high, and so essentially most people wouldn't be able to meet it, because most people wouldn't be as cautious as this hypothetically cautious reasonable person. If the standard of care was of a reasonable person who was too risk-taking, well then surely the standard of care would be too low and everybody would fall inside it, and then nobody would be able to find liability in the case of breach. So essentially, a reasonable person is just a very standard, bog-standard individual who is neither too cautious nor too risk-taking. In 1943, we get the case of Glasgow Corporation and Muir, who essentially is a case in which the defendant had been working in a tea room, and they had accidentally spilt a pot of tea onto a group of children, and this, of course, would have caused some injury owing to the temperature, scalding some of the children in the process. Now, the court was invited to examine what the standard of care would have been in this scenario, and whether or not the defendant had therefore gone above or beyond that standard of care, above or below, should I say, resulting in the spillage itself. Now, the reasonable person test, as established in the previous case, was applied objectively, and so where it was held, essentially that a reasonable person, acting in the circumstances that the defendant had been acting in, would not have reasonably foreseen that the accident could have happened or would have likely have happened, and so as a result of which would not have reasonably foreseen that there would have been a cause of injury. It was seen to be the case that a reasonable person, in this example, a reasonable person acting in this scenario would not have done anything really any different to the defendant, and so as a result of which they were not liable in the tort of negligence because they didn't fall below the standard. A reasonable person would have acted in a very similar way to the defendant in this case. In 1971, we get the case of Nettleship and Weston, and now this case is important because essentially what it does is it shoots down the idea that, for the most part, we should adjust the standard of care. We should adjust it on the basis of somebody's age, maybe somebody's temperament, or maybe for some other factor. We will get to the application of the standard of care when it comes to children in a future lesson, because the standard of care does adjust, but only in certain circumstances, i.e. the age of the child has to be significantly lower than that of the age of majority, essentially. But the case of Nettleship and Weston talks about the idea of competence and the idea of the varying levels of competence and whether or not this could adjust the standard of care in these examples. So the courts have often been invited to adjust the reasonable person standard for different circumstances, and this case is an example of the courts being invited to do just that, but also being reluctant to do so as well. And we'll look at exceptions in the next lesson. So this was a case which involved a learner driver who had crashed into a tree, causing relatively minor injuries to the non-qualified driving instructor. So there were some injuries, but nothing was too serious. Now the question for the courts was whether or not the reasonable standard and the reasonable person test should be applied objectively. Would the courts approach it from the perspective of that of a learner driver, or would they suggest that the reasonable person is a reasonably competent driver? So should there be a different standard of care? Should the standard of care be applied, be the application of a reasonable person who is a learner driver, and so therefore be slightly lower, which would then probably have meant that the defendant would not have been in breach of said standard? Well, Lord Denning concluded that the standard of care in this case was that of an experienced, skilled and careful driver, so applying an objective test and seeing that essentially the defendant had fallen below it. So the result was that they were liable for breach, or at least the issue of standard of care was not one that was going to be discussed in this case. And so as a result of which they were found liable in negligence. The non-qualified driving instructor also had some claims against them as well, or at least there was a reduction in the claims on the basis that they were a non-qualified driving instructor. But this case was very important in the sense that it showed that the adjusting of the reasonable person standard, up or down, essentially is one that is very reluctant, a reluctant choice on the basis of the courts. And so there will be exceptions in the next lesson to where this takes place, but for the most part, the courts are reluctant to adjust this reasonable person standard. In this lesson, what I want to do is talk a little bit more about this reasonable person standard. And we will talk about the circumstances, or at least some of the circumstances, in which this reasonable person standard is actually adjusted. Now, we noted in the previous lesson that the courts have been consistently reluctant to adjust this reasonable person standard to a higher or lower amount, specifically and especially to a lower level, owing to the fact that for the most part, the reasonable person test is an objective test and is a test that is supposed to be as objective as possible and not supposed to be determinate on the basis of individual cases and the facts of individual cases. But it is not always the case that the courts are reluctant to simply keep, or at least reluctant to adjust the standard lower. And this is what this lesson is going to be about. It's going to be talking about circumstances where we talk about the exceptions to the basic reasonable person standard. And by exceptions, I mean circumstances in which the standard is lowered. The most pertinent of this relates to children as defendants. So what about circumstances where the defendant in question is a child? Let's say they're 13 years old. Should we apply the reasonable standard of a reasonable man or a reasonable woman of adult age to that of a 13-year-old child, and so suggest that basically in any circumstance they would be found to have been liable in tort, because children, for the most part, probably do not act in a way or in accordance with that of a reasonable person. Or at least it should be assumed that that is going to be the case in a lot of circumstances. Well, it has been held in cases that are subsequent to that of Nettleship and Weston that when we talk about the standard of care as applied to that of children, when we think about and add children to the mixture, essentially what we have to think about is whether or not this ought to adjust the standard and maybe lower the standard slightly. So where the issue relates to a child defendant, the conclusion that the courts have come to is that the reasonable person test should be adjusted to that of not just a reasonable person, but the reasonable person of the age of the child in question. So we essentially adjust the standard. So if we were thinking, like I said earlier on, to the idea of a 13-year-old maybe potentially being a defendant in a tort case, the standard is therefore adjusted to that of a reasonable 13-year-old. So what would a reasonable 13-year-old have done in the circumstances? This is seen as a more just solution to the concept of adjusting these standards and making an exception to the standard of care in order to essentially allow for a defendant who is a child to have a fair hearing in terms of their decisions to act in a particular circumstance. Because for the most part, owing to brain development and maturity and all these different factors, children probably do not act in circumstances which are of the standard of a reasonable adult. And so the result of that means that they would have to adjust this standard slightly. But the resulting adjustment of standard means that essentially we allow for a more just settlement for children. But the reasonable standard of care for children is still not entirely as simple as this, okay? And we'll talk about the case of Mullen and Richards in a second, but ultimately, the courts have been asked the question of the reasonable standard of children, and they've been told that, they've said essentially that we will adjust it to the reasonable age of the child in question. But what does that actually look like in terms of a shift in the standard? Does that actually significantly lower the standard in any meaningful way? Well, the ultimate conclusion here is that when we think about the reasonable standard as applied to children, the closer the age of the child gets to the age of majority, the less of an impact that this adjustment will actually have. If we're talking about a reasonable 13-year-old, then we could probably expect that the standard of care is adjusted quite significantly and quite significantly lower to account for the fact that we're talking about the reasonable standard of a 13-year-old. But what about somebody who's 17 or 16? Well, it is held that, essentially, the closer we get to the age of majority, the closer we get to an 18-year-old, the more the standard of care of a 17-year-old, for example, or the reasonable person who is 17, will just look like the standard of care for a basic adult. So the closer and closer that we get to the age of majority, the less and less of an impact that this exception will actually have, and the less and less of an adjustment this will actually be. So let's think about this in reference to the case of Mullin and Richards from 1998. In this case, both the defendant and the claimant had been schoolgirls who had been playing with plastic rulers and had pretended to have a sword fight with the plastic rulers. One of the bits of plastic would actually break in the course of having this fight, and a sharp fragment of plastic had gone into the claimant's eyes, blinding her in one eye. So quite a horrific incident that had taken place. Now, we all know, if we've all remember being at school, knowing that those plastic rulers aren't particularly sturdy, so something like this would have happened, is likely to have happened reasonably. When the question of negligence arose, the question of whether or not the defendant, in this case the other schoolgirl, who had ultimately acted in a way that may have caused the sharp fragment to have gone in the claimant's eyes, the issue immediately turned to the issue of the standard of care. It became one of apparent importance. The two girls were 15 years old, and so the question was, should the standard of care be that of a reasonable person, i.e. a reasonable adult who was acting in this circumstance, or should it be the standard of care of a 15-year-old, a reasonable person who was 15 years of age? The courts held that, where it came to issues relating to that of children, the reasonable person standard ought to be adjusted to essentially account for the fact that these people are younger than the age of 18, and they are not adults yet. And so as a result of which, the reasonable person is probably the reasonable person of the age of the defendant. So the reasonable person is a reasonable 15-year-old rather than a reasonable 25-year-old or reasonable adult. Maybe an adult acting in this circumstance would have acted in a way and reasonably have foreseen that this kind of damage or injury could have occurred. But would a reasonable 15-year-old have had that same foresight in terms of their actions? Potentially not. And so the result of this means that we adjust the standard of care slightly lower. So the standard of care was not judged in this case to be the standard of an adult, a reasonable adult, but in fact a reasonable 15-year-old. So essentially, that's what the standard of care as applied to children essentially represents. And as I mentioned earlier on, the adjusting of the standard will be on the basis of the age of the child, but the closer that we get to the age of majority, the more that it will reflect that of just a reasonable adult. So somebody who is 17, for example, there's probably no difference in terms of the standard of care for a reasonable 17-year-old versus a reasonable adult, a reasonable 18 or 19-year-old. There tends to be no difference in those regards. It's only in the circumstances where we're talking about quite significant age distinctions, so things like 13 or 12 or 15 or 14 in these cases, where we start to think, well, these people are probably very different and will act in a very different way to that of 20 or 23-year-olds, for example. So, like I said, when a defendant is, for example, 13, the reasonable standard would probably look quite different to that of if they were just an adult. But if they were 17, while they're still not an adult, the reasonable standard would probably on its face be that of an adult. It will look very similar to that of an adult, given the fact that there is very little delineation that one can reasonably make between that of a 17-year-old and that of an 18-year-old. So the previous lesson talked about the adjustment of the standard of care when making considerations in relation to defendants which may be, or who may be, children. This video is going to talk a little bit more about different standards of care and different relationships that come to the various different specialisms that people may have, and whether or not this could adjust the standard of care. What if somebody is a trained professional in the area in which they are supposed to be, or they're supposed to have a duty of care, and then they breach the duty of care? Should a reasonable person test be applied in that circumstance? How does special standards actually apply in the law of tort here? These are all the questions that we're going to ask in this lesson. Like I said, the previous lesson, spent some time discussing the issues relating to the idea that the standard of care may be adjusted, probably and potentially adjusted down when it comes to cases involving a child who is a defendant. We noted that even in the circumstances where a child is a defendant, there will only be an adjustment of the standard of care that reflects the standard of a person who is of that age. And the closer that you get to the age of majority in that circumstance, the closer the standard of care that is applied to that child will just represent and reflect that of a normal standard of care that you would apply to an adult. In this lesson, we're going to talk about the circumstances where the standard of care will be adjusted on the basis of specialist skill and knowledge. So somebody who may be a specialist or maybe have or should reasonably have specialist skills and knowledge in a particular field or circumstance, such that the standard of care should be adjusted to apply differently to those people instead. So if an individual who is involved in a particular negligence case as a defendant, they're being accused of negligence, for example, happens to also be an individual that has a very specialist skill and knowledge in a particular area, then the courts will take into consideration that specialist skill and knowledge when it comes to the establishment of a breach of duty. Now, the specialist skill and knowledge will also probably have to pertain to the kind of issues that are at play in the case itself. Just because, if, for example, we're talking about a general case of negligence in relation to driving, for example, the fact that the person who is a defendant has specialist skill and knowledge in the area of history, let's say they're a historian, that probably wouldn't qualify as being specialist skill and knowledge in that field. You have to be specialist skill and knowledge in the area that would reasonably expect you to have a certain amount of deference to a duty of care, such that the standard may be adjusted to account for this due deference to the standard of care. It is sometimes known as the Bolam principle, and this obviously comes from the leading case on this area, which is the 1957 case of Bolan and Fryan Hospital Management Committee. The specialist skill and knowledge on display, should I say, in this case, was that of a qualified doctor, and that the case was in the context of medicine. So obviously there has to be like I've said, there has to be a conjunction of the specialist skill with the issue at hand. Okay, so this was a case where the negligence was in the context of medicine, and the specialist skill and knowledge was that of a doctor. Okay, so this makes sense. The defendant had failed to inform the patient, the claimant, of the risks which may have been involved in a particular type of treatment. The treatment in question was electroconvulsive therapy. The patient had therefore been injured in the course of said treatment. And the courts held that the test is the standard of an ordinary skilled man exercising the profession to have that special skill. So when we think about this here, if we're talking about cases of medical negligence, it probably wouldn't make sense, actually, it definitely wouldn't make sense for us to apply a standard of care of an ordinary person, of an ordinary reasonable person, in the context of medical negligence, given the fact that an ordinary reasonable person probably isn't a qualified doctor. And so as a result of that, the specialist knowledge and skill that is on display of the qualifications of the person who is being accused of negligence has to be taken into consideration, because otherwise essentially no medical negligence case could actually ever or for the most part could never actually result in liability. So therefore the Bolam test ascribes the idea that the test is the standard of the ordinary skilled man or woman exercising and profession to have a special and professing to have that special skill. So you take into consideration that instead of it being just an ordinary person, it is an ordinary person of that particular skill. So it would be, in this case, the idea of a qualified doctor, it would be an ordinary doctor, okay? An ordinary doctor who is performing these procedures. What would they have done in that circumstance? And that's where the standard of care is adjusted, and this would probably objectively adjust the standard of care higher, to a point where there is probably a higher bar to meet for a standard of care. The Bolam test illustrates here something of both an objective standard as well as a subjective element as well. So for the most part, the standard of care we have noted is something that has to be objective in nature, an objective reasonable person test. Whenever we make reference to a reasonable person test, this is always an objective standard. But it will also illustrate something of a subjective standard as well, because the objective part pertains to the idea that the Bolam test still represents a reasonable person. There is still a reasonable person that has to be adhered to, essentially, and this is the objective element of the test. But the subjective element is the bit where we talk about the reasonable person who is professing to have that special skill. And so as a result of which, the courts will have to adjust the standard on the basis of the facts of the case. That's what makes it subjective. The facts of the case, if it is a case involving a professional doctor, then they will adjust the standards accordingly on the basis of it being a professional doctor. If it is a driving instructor, maybe there will maybe be an adjustment of that case on the basis of a professional driving instructor in cases that involve car accidents. In 2015, we see the case of Montgomery and Lancashire Health Board. As you would probably imagine, a lot of these adjusting of the standards cases often take place within the context of medical negligence. In this case, we see another example of negligence claims that are taking place. Like I said, they are taking place in the context of medical examinations and medical procedures. The procedure here was a method of birth, and the mother had not been informed of the potential risks that may have been involved within this particular method of birthing procedure. And so the result was that the baby would be injured in the process of this birth. The courts concluded that the correct standard when it comes to the granting, to the consent granted, was that of a reasonable person who was in a position of the patient, and their consideration would be therefore material. Again, representing something of an adjustment to the standard of care and a subjective element, applying the standard to the facts of a particular circumstance. Welcome back, everybody, to the Law of Tort. In this video, we are continuing talking about the breach of duty and the standard of care in the context of negligence. And we're going to focus on this idea of the application of the standard of care, being able to apply the standard of care to factual circumstances. Now, we're going to cover a couple of cases, and then we'll cover some instances by which it is validated in the way in which we can essentially apply the standard of care. We'll talk about how the standard of care is established in a number of cases as well. So, when we think about the standard of care, and when we think about the application of the standard of care, there has to be a number of considerations that we have to keep in mind. Don't forget, the application of the standard of care is essentially taking all the things that we have looked at in previous videos, talking about things to do with the reasonable person, maybe making adjustments on the basis of the Bolam test, or even making adjustments lower on the basis of the consideration of defendants being children. And then actually taking all these informations, taking all these principles, and then applying them to the factual circumstances of a particular case. Now, the considerations that we have to think about was the extent to which the magnitude of risk existing in the performance of a particular action. What was the magnitude of risk? Was it an unjustifiably risky action? Or was it something that was particularly not conducive to a significant amount of risk? Did the defendant take any precautions to avoid any kind of risk? And so when we ask these questions, these are the two questions that we generally consider. And when we think about it, the magnitude of risk essentially asks the question of how risky, how dangerous was the action in question in terms of potentially giving rise to the events that take place that causes some kind of damage. And then given the fact that there is a certain amount of risk, what precautions could have been taken and what precautions were taken by the defendant in order to avoid or minimize the risk that was had. Take the first case example that we're looking at today, the case of Bolton and Stone. The facts of this case involve the defendant who had been playing cricket in a club. The ball would ultimately fly over the fence of the club, where it would subsequently hit a pedestrian who was walking down the street and just walking past the cricket club where the ball flew. For anybody who has ever held a cricket ball, they're not like a tennis ball. They are very, very solid. If you get hit in the face or in the head with a with a cricket ball, that's going to really hurt, depending on how the velocity. It would really hurt a lot more than any other ball that I can think of, really, except for maybe a billiards ball. The question here was that of an application of a reasonable person standard. So essentially we're asking the question in this case about whether or not there was a breach of the duty of care, and whether or not the defendant, who was just simply playing cricket in the club, had gone below a standard of care in being able to minimise the amount of risk to the potential claimant. What was the magnitude of risk? And what actions were taken by way of precaution? Were these precautions reasonable? Were they reasonably expected of a reasonable person? Okay. The courts held that the likelihood of something like this happening was relatively low. So in terms of asking the question as to the magnitude of risk, they concluded that there wasn't a particularly high magnitude of risk. There are a few reasons for this. Firstly, it was only on rare occasions that the ball would actually ever fly over the fence, and then even in those cases, the chances of that actually leading to an individual being hit would also be very, very low. And then on top of that, the idea of an individual being hit and then seriously injured as the result of all of these factors all suggested that there was a relatively low magnitude of risk. It was also noted that there was an option for the club to install a larger fence, but the cost of doing so was seen to be invasive. So while it was seen to be the case that this would have been a precaution that could have prevented the injury from happening, this was seen to be something of an unreasonably high level of standard for a precaution for something of this nature, given the fact that the magnitude of risk was so low, and the cost and the invasive nature of installing a larger fence was so high that it led to a situation where it was seen to be a bit higher than a basic standard. So given all of these factors and taking them into consideration, the playing cricket in the manner that was stated was seen to be within the reasonable expectation of the standard of care, and so the claimant had no negligence claim. There was no breach of duty, given the fact that this was generally within the reasonably expected standard of care. A few years later, we get the case of Overseas Tankship United Kingdom and the Miller Steamship Corporation of 1966. This is sometimes referred to in textbooks and in the case law as the Wagon Mound number 2 case. We will get to the first Wagon Mound case when we talk about remoteness in a future lesson. But this case involved negligent action in the releasing of oil into Sydney Harbour. Essentially, what had happened was there was a boat which had released oil, a tank ship had released oil into Sydney Harbour, which had then spread, and as you know, or should know generally speaking, the oil floats on top of the water. Sparks from a nearby welding operation led to the oil igniting and causing a substantial fire which would damage other items that existed in the harbour. Now, the Privy Council asked the question as to the extent and the magnitude of risk in these circumstances. So, were the people who had allowed quite negligently the oil to spill, were they liable for the damage that was caused by the fire? Well, what was the magnitude of risk for the oil catching fire? Given the fact that it was floating on top of the water, and given the fact that the welding operation was a little bit further away than the oil tanker, it was seen to be the case that there was a relatively low magnitude of risk in terms of the risk of the oil actually catching fire. No one really believed that would be something that would happen. But however, it was still nevertheless present. There was still a risk that existed. Balancing this idea against the fact that there was no reason for the oil to be released in the first place, nor was there any cost in keeping the oil from spilling, it meant therefore that there was a failure on the part of the defendant to meet the standard of care of a reasonable person. The reason why this is the case is because the the Privy Council at least, balances out the relatively minor risk with the even lower standard by which it would have been easy to fulfill in the ensuring that there was no oil being released into the harbour in the first place. So everything was relatively low in terms of risks and in terms of actions that could have been used and utilised to prevent said risk. And so even though the oil catching fire was a relatively minor risk, there wasn't much magnitude of risk, it was still nevertheless one that could have been prevented by very menial and very cost-effective and very, very easy decisions on the part of the defendants. And so as a result, there was a failure on the part of the defendant to meet this standard of care.